And now I'm going to move with the second topic about administrative disputes. So I'm going to share my screen now. Okay, perfect. So in this section, I'm going to talk about oppositions, cancellation actions, and well-known trademarks, which is actually an important topic, and I just thought that it was important to have it perhaps in this second section. So let's talk about Andean oppositions. Of course, many of you may know that once you have a trademark registered or even in process, you have the right to challenge another trademark that might conflict your rights. Of course, this can work within your jurisdiction. But for the Andean legislation, actually, we have what is known as Andean oppositions. So what does it mean to have an Andean opposition regulation in that sense? So after, of course, you have passed the formal examination stage, your trademark will be published. For example, let's say that I just filed a trademark application here in Peru. So the trademark application is published in the official gazette of the administrative authority here, of the trademark office. And third parties will have 30 business days to challenge my trademark application. But in the case of the Andean opposition, this means that any other country of the Andean community can actually file, or any other applicant that has a prior application or registration in these other Andean countries can file or can challenge my trademark application here in Peru. So in this scenario, for example, a Colombian owner of a trademark registration files an opposition based on his Colombian registered trademark. But in order for the opposition to proceed, the trademark office from Peru will request the Colombian trademark owner to file a second, or to file an application here in Peru. So this second application is to demonstrate to the authority that the Colombian oppositor or challenger has an actual real interest in the Peruvian market. So he would need to file a trademark application here in Peru to demonstrate this real interest in the Peruvian market. This is one scenario. The second scenario is in which case the Colombian opponent doesn't need to actually file an application here in Peru, because he has already one trademark registered, or one trademark registration here in Peru as well. So he might have another Colombian trademark registration already granted in Colombia prior to that Peruvian trademark application, and also he has a Colombian registration in Peru. But once he files a position, it would be based on the Peruvian registration, but in the Colombian registration. So actually that responds to perhaps some strategies that the owner may have in Colombia. Maybe he's not perhaps using the trademark in Peru, but he wants to challenge the trademark based on his Colombian registration. That may be one. And of course, in that sense, it's perhaps easier in that sense. Then I'm going to talk to you about how actually proofs of use work regarding cancellation procedures. So it's a bit more complex than that, but the main idea here is that you can file or you can challenge a trademark application in whichever country of the Andean community based on another trademark application or registered trademark of another Andean country. So actually, it's not, of course, as you can see, is that we don't have actually an Andean community trademark, but based on these innovations within the Andean legislation, we can have these, let's say, advantages for the trademark owners or applicants. And as I was telling you, the cancellation proceedings also are particular here in the Andean community. Of course, if someone wants to challenge your trademark because on the grounds that it's not being used for the last years, it would be within your jurisdiction. And in that sense, you will need to file proofs of use or evidence of use of how you use actually the trademark within your jurisdiction. But in the Andean legislation, if you receive a non-use cancellation action, you can actually submit evidence of use from other, let's say, market activities in other parts of the Andean community countries. So, for example, if I receive a non-use cancellation action against a registered trademark in Peru, I will need to submit evidence of use. And I can actually submit evidence of use if I have economic activities in Colombia with my trademark, or in Ecuador or in Bolivia. So actually that makes things easier for the trademark owner to actually defend his trademark rights in the Andean community. Of course, there are many types of evidence of use. Ones that are regarding products offered in the market, or maybe if you already engage in commerce, you would have to submit bills, for example, as proof of use. Or if you're exporting from any of the member countries, that would be also proof of use. So those are the main categories when you want to actually prove use of your trademark in the Andean community, in a specific country of the Andean community. Now, there are some conditions. For example, if you have already your trademark registered in Peru, if someone wants to cancel your trademark, that third party will need to wait 3 years, counting from the trademark registration. Let's say that's a simple, let's say, example of how this time frame works, because it is counted actually from once the final administrative decision that grants your trademark becomes final. That's like, let's say, the technical analysis regarding these 3-year terms count. But let's say that in another way, in a simple way to see how it actually works is, once you have your trademark registered, third parties will need to wait 3 years for filing a non-use cancellation action in that sense. And if you receive this non-use cancellation action, you would need to prove your trademark within a 3-year period. That's a relevant period in which you will need to prove that actually you use your trademark. And let's talk about well-known trademarks, which is actually a really important topic. As you know, well-known trademarks have better, let's say, a broader protection regarding regular trademarks. And of course, if we talk about that trademark principles, we know that one principle is about specialty. So when you file a trademark, it's because you want to register that trademark for a specific class. But when we talk about the protection of well-known trademarks, actually, this principle of this classification or principle actually gets flexible. So if you actually are protecting your well-known trademark in the Andean community, the examiner will be more flexible regarding that, and you will have a broader protection that goes even further than this classification. So in that sense, of course, you would need still to prove that that trademark application is within the relevant sector. But here it's important to know that, of course, when we talk about well-known trademarks, we also perhaps think about renowned marks or renowned trademarks. For example, Pepsi or Coca-Cola that are really renowned trademarks globally. And here in the Andean community, our legislation is not framed for renowned trademarks, but just for well-known trademarks. But despite that fact, uh, the Andean community, the Andean Community Court actually stated through a decision that actually you can still have protection for renowned marks, but within that well-known trademark regulation in that sense. So you need to prove that you have a well-known trademark in the Andean community, and of course, it is sufficient for the mark to be well known in any of the member countries of the Andean community. So if you want to prove that you have a well-known trademark here in Peru, you can use proofs from Colombia or Bolivia. So that's of course an advantage regarding the trademark legislation system. But there is something also important that is actually connected specifically to Peru. We just recently, the trademark administration has issued a decision, or let's say a resolution that states that once the trademark administration states and recognizes that you have a well-known trademark, you will have this category or this status for 5 years. Once these 5 years have elapsed, then you will need to file again proofs of use, or sorry, proofs that your trademark is well known. But this is quite new, but for the Peruvian legislation, it doesn't work like that for Ecuador, Colombia, and Bolivia. Once you want to protect your trademark on the grounds that it's a well-known trademark, you would still need to submit proofs that it has that condition. And in order to prove that actually you have a well-known trademark is actually proofs that show that you have a well-positioned trademark in the market. And for that, you need, of course, quantitative proofs, which means that you have offered your trademark in a long period of time, that you actually have a lot of commercial transactions regarding your trademarks as well. And for the quality analysis, you would need to prove that perhaps it's well positioned in the mind of the consumer. It's in the top of mind. For example, if you talk about a category of soft drinks, what is the first thing that comes to your mind? So it's perhaps a good type of proof that you would need regarding this quality proofs is regarding the top of mind. So it's more a consumer approach regarding, or a consumer psychology approach regarding this type of quality proofs of use. Okay, so this is my presentation regarding the second topic. Of course, there are other administrative disputes, or we have other institutions as nullity actions, for example, but I think that the Andean opposition and cancellation proceedings are really frequent when you want to enforce your rights. And of course, well-known trademarks is an important figure for you to know. So in case you want to, of course, for example, file an opposition or challenge a trademark application, and you can, of course, argue, or this opposition can be based on the grounds that you have a well-known trademark. And it's important for you to know that it's actually, since we are within this Andean legislation, you have the advantage to actually prove that you have this condition based on other Andean community countries. So yes, that's the second topic of the webinar.